Swayam Prabha. Digital India. Educated India.
Dear students, let us discuss the next category of intellectual property law, intellectual property rights, that is industrial designs. And what do you mean by industrial designs, or whether designs can be registered as a part of intellectual property law. And industrial designs are nothing but, you can see some of the industrial designs, how it look like. And all these are designs which can be registered and which can be protected as intellectual property rights. And if you look into the definition of design, what do you mean by design? Section 2D of the Indian Designs Act, which defines a big definition, a long definition, an inclusive definition of design. And the Act says that the design means only the features of shape, the configuration, the pattern, the ornament of composition of lines or colors applied to any article, whether in 2-dimensional or 3-dimensional or both the forms, by any industrial any industrial process or means or manual, mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. This is the first part of the definition. It means that the design is judged solely by the eye. Solely by eye means, it means that it is the visual appearance which give you the design, and the definition which clearly says it is a features of shape. It can be shape, it can be configuration, it can be the pattern in the material, and also it can be the composition of even the colors, that also can be registered as a design. And it clearly, in the second part of the definition, it clearly excludes, and or it can say that it says it does not include any mode or principle of construction or anything which is in substance a mere mechanical device. For mechanical device, you go for, if it is new, you go for patenting, and does not include any trademark defined under the Trademark Act, or section any property mark defined under the section 479 of the Indian Penal Code, or any artistic work as defined in clause C of the Copyright Act. Because for artistic work, you go to the Copyright Act and you register it as copyright, and for trademark, you go to the trademark and you register it as a trademark, not under the designs. So, design is exclusively the visual appearance, or it is solely judged by the eye. And you can see the different shapes, it can be different shapes, whether it can be 2D patterns or it can be 3D patterns. It can be shapes, it can be lines, it can be composition, it can be color, and it can be even, you can see the combination of both 2D and 3D. So, that it is aesthetic to the eye. The aesthetic appearance is actually the registrable as design. If the aesthetic aspect is new, it can be registered as a design. And also you can find n number of materials, industrial designs. So, which can be registered. It can be a design of a vehicle, it can be even design of a bottle, it can be design of a chapel. So, this can be registered. So, whether it is a 2D or it is in the medium of 3D, it can be registered as a design. So, I would say that a number of materials which can be even a small, the design of a clip also can be registered. So, that it can be protected as an intellectual property, and the protection is for a minimum period of which you can find the statutory period, it can be protected. And you can see that this definitely this is a beautiful bike, but the design is registered. It means that because as far as the vehicles are concerned, the design gives an aesthetic, the complete aesthetic look to that particular model, and these vehicles are sold mainly because of its models and its aesthetic aspect and its design. So, this can be registered as a design. So, industrial design, and most of the industries we can find that some of the industries like these, for example, the bike industry or car industry is entirely surviving on the protection of designs. If the designs are copied, the direct designs are copied by its competitors. So, they are going to have a lot of economic loss. So, these designs can be registered. When we look into the designs, so simply we can say that it is the overall appearance of that particular product to our eye. So, the overall appearance must be new, then only it can be registered, and it can be the shape, it can be the pattern on that particular product, and it can be the ornamentation, and also it can be applicable, or it means that the visual appearance must be unique, then it can be registered as a design. And then whether it can be the product is manufactured or it can be handmade. So, these patterns can be there, this ornamentation can be in that particular kind of product which can be registered, these designs can be registered. And the operation of the work is not concerned about the designs, but because the operational aspect of the materials, the goods can be considered by the patent law, not by the design law. And the design law actually look into the aesthetic aspect or look of that particular product. For you can see, for example, you can see this beautiful cycle, and of course, this cycle is entirely going to be sold based on its new the new it is the new design which is in it, which we are not seen in the market. So, if it is copied, then it is a complete economic loss to the inventor of this particular design. So, who is made this particular design. So, the entire aesthetic aspect, that is the crux of the design registration. And industrial designs, as I told you, the article always the design enhances the visual appearance and it differentiates between the products. The visual appearance, if it can be the same product, but the visual appearance differentiates that particular product. That means, if it differentiates a new pattern or a new visual appearance, then definitely it can be registered as a design. Sorry. And mostly you can see that if you go to the market, you can find the perfume bottles are different designs. So, these bottles also can be registered, it can be 2D patterns or it can be 3D patterns, it can be registered. For example, we have talked about these 2D patterns. So, you can see a series of materials where it can be electrical, where it can be non-electrical, it can be a writing pen, or where it can be a timepiece, or even some the designs of chapels. All these can be the consumer products can get a design registration. So, once the design is registered, nobody else can copy it for a limited period of time. And you can see that what are the things when it can be registered a design. It must be new. It must be new in the meaning, it means that it must not be identical to any design previously published anywhere, which is previously available in the market. And also you can see that means now because of the advantage of technologies, the internet and other things, and the examiners can search and find out whether this is already published anywhere in the world. So, it means that it should not be earlier published or previously published, then only it will be considered as new. And the second criteria for design registration is the distinctiveness. The distinctiveness, it meaning it must not be substantially similar in overall impression. So, it means that the goods can be the same, if you put a different pattern or a different overall look to the already existing material, that particular design can be registered, but it should not be published earlier anywhere in the world. So, that means it must be new, it must be distinctive, but substantially if there is a difference, then it can be registered as a design. And if you take even pharmaceutical products or some industrial products, even the syringes, the designs of syringes also can be registered. The designs of capsules can be registered. Now, most of the pharmaceutical companies are going for registration of the shape of their tablets, because it may have an aesthetic. The people, the consumer identifies that particular tablet based on the color of the tablet or the shape of the tablet. So, the consumer easily identifies that particular product. So, there are different varieties of products, even pharmaceutical products are not devoid of design registrations, it can be registered. So, it means that the criteria for design protection is it must be new, it must be distinctive, it must be original, and the most important criteria is it must be capable of mass production or application of an article of utility. This is also very important. If you make a prototype of one prototype, that is not it cannot be registered as a design, there must be a mass production, industrial mass production of that particular product, then only it can be registered as a design. And the design should not be contrary to public order or morality as well. So, this is the one criteria where the all applicable to all intellectual property rights. All intellectual property laws prescribe that the invention or the design or the copyright should not be contrary to public order or morality. So, if you want to get a protection, it should not be contrary to the public order or morality, but public order and morality changes from place to place, society to society and countries to countries. So, what is the standard of public order or morality is not defined in any of the Indian intellectual property law. So, it may the court may interpret it according to case by case or circumstance of each case. So, that means you can see that the functionality of the goods are not the concern of the design, it is the aesthetic aspect is the subject matter of design registration in India. And you can see that we have talked about the 2D products as well, the textiles and jewelry. The jewelry is nowadays, if you go to the market, and we know that the jewelry, the designs entirely depends upon the designs. There are so many designs which are available. If it is new, it can be also registered as a jewelry design. So, very well. So, you can find whether it is a chain or it is a earring or it is a ring. So, it can be registered as a design, particularly it is as a design which will preserve their shapes. So, you can find even some unique shapes which is given to the aspects, it can also can be registered as a design. This can be recognized as a design. So, that means the patterns in a vessel can also be registered as a design. And you can see this is a 6-piece coaster set. So, means everything is coaster set, but it is a shape of pineapple. So, this can be very well registered as a design, because it gives the aesthetic aspect is very important, and it give you an intellectual property right on designs. So, this is one of the famous case, so designs registrations can be end up in high value suits. So, here one designer accused another designer of plagiarism of design. So, this is a news item says the plagiarism of design, which is used in one of the famous movies and ultimately that case has been settled by the designers mutually, but what I want to say that a design which is a famous one, if it is used in movies and other things, it can become very famous, very quickly it become famous and can quickly become viral. So, it means that you will end up in trouble. There can be a huge suit you may be facing for violation of designs even in textile items. And most importantly, you can see that in a single item there can be multiple intellectual property rights protection. For example, you can see this particular picture where you can find some of the copyrighted materials which you can find, or copyrightable materials which you can find. You can see the trademark registrations, and also you can see the design rights, and also you can see the license material also. That means even multiple intellectual property rights which you can find it in a single person, which we use different materials on day to day basis by the human beings. And if you look into some of the disputes which you can find, it is interesting disputes which you can find. So, industrial designs, whether copyright protection can be for designs as well. So, if copyright material, if a copyright is already, if something is already copyrighted, can you protect it by designs? But our Designs Act says other way around, that if it is registered as a design, it will be, you will get an automatic copyright protection, not the other way around. That means, is a copyrighted protection, copyrighted material, you are not going to be get design protection, but design registered materials are going to get a copyright protection as well. So, it means that so there can be multiple protection for the same products if you register it. And if you compare the industry designs with trademarks, so designs are always an integral part of the product, but trademarks are applied on the product, but need not be embedded on that particular product. And industry designs also, it must be original, new, but need not be distinctive. In the case of distinctiveness should be proved, and the trademark, it must be distinctive as well. So, if you compare it with patent, copyright and industry designs, you can say that the only exception is that the article is not, mass production is not there, the designs cannot be granted, and even though it is a useful article, the design would be an aesthetic work, or it is protectable under copyright. If it is aesthetic work, it can be protected under copyright as well. And here you can see that even engineering designs also can be, it is not under design, it can be protected under Copyright Act actually. So, here also you can see some of the apparel works which you can get designs. So, it can be for jackets, it can be for the aesthetic aspect is always has looked into the registration of designs. And we have registered some of the textile products from the Orissa. So, you can see the certificate for what. So, this is actually a wall hanging. So, which is this particular design we are registered, Rajiv Gandhi School has registered this particular design on behalf of the Sambalpuri Bastralaya or Sambalpuri Bastralaya Handloom Cooperative Society in Sambalpur in Odisha, and this is a wall hanging. So, the peculiarity of this wall hanging is that usually the clothes are made up of weft and warps, and this is only one, it is made up of one side, this is only one side, not both the sides. And we rested its wall hanging is this particular, you can see the tribal motifs, the specific motifs which is very particular to Odisha. So, it is registered, and we have registered it in 2010, the year 2010, and we got the certificates, and you can see the others as well. All these are textile products, and these designs, the specific designs, the motifs in the so the aesthetic aspect is clearly it is written here what is new in it. The novelty resides in the surface ornamentation and color combination of the wall hanging as illustrated. So, this anybody can make this, but this design is already registered, and it is for the design registration is for the surface ornamentation and the color combination of which is claimed in this particular wall hanging. And this is the third one, again you can see the specific motifs and also the surface ornamentation very specific. So, we are registered this on behalf of the Sambalpuri Vastralaya from Sambalpur and Odisha. So, there is some exclusions as well from the registration of designs. So, that means any mode or principle of construction or anything which is in substance mere mechanical devices are non registrable. A trademark cannot be registered as a design, property mark cannot be registered as a design, and artistic works cannot be registered as a design. All these are the appropriate protections under the Copyright Act, and also we can find the Trademarks Act and even Patent Acts. And piracy of designs is one of the important the menace which is in the market. So, that means the registered proprietor of the designs is see you can find it is the damages are also is prescribed in the particular act. So, the registered owner can ask for an injunction, ask for damages under, so which is prescribed under this particular act. So, the piracy is also there is the remedies which is available in the act itself. So, industrial design, as I told you, it is the commercial exploitation of the design or the idea or the creativity which is coming from the author, which can be protected under this particular Designs Act. So, I want to say that this is the design registration protection is very important for some of the industries, industrial products, and which can make lot of economic benefit out of the design registration, and this is one of the important category of intellectual property protection. Hence, this should be taken very seriously by the government as well, and which is implemented strictly in India as well. So, I hope that the students may get an idea about the broad aspects of design registration. Thank you.